Good afternoon. I'm Larry Broomfield, co-chair of the healthcare department at Reinhart Burner Van Duren. I, along with Tracy Klein, who co-chairs our healthcare department and leads our hospital and health system subgroup, welcome you to the presentation on fair market value of physician compensation. Tracy and I are glad you're here today, in person or through the webinar. We first want to thank our speakers, our special guest, Mary Hammonds of Integrated Healthcare Strategies, and our very own Lucian Beaudry and Nicole Rosen. My partner, Heather Fields, will tell you more about them later. Reinhart employs more than 200 attorneys who are dedicated to providing efficient and effective services from our 7 offices throughout the country. One of the nation's 250 largest law firms, Reinhart has offices in Milwaukee, Waukesha, and Madison, Wisconsin, Chicago and Rockford, Illinois, Phoenix, Arizona, and Denver, Colorado. As some of you may know, we recently opened our Chicago office in the Willis Tower. Through our work with the best consultants in the country, like Integrated Healthcare Strategies, we are able to offer the expertise our clients need. This program is an excellent example of what we offer. It is an effort made possible by Reinhart's tax-exempt organization's practice. This practice assembles the experience of Reinhart lawyers drawn from all of the disciplines, including healthcare, tax, employee benefits, employment, banking and finance, real estate, and trust and estates. We represent numerous charitable and educational organizations, long-term care facilities, hospitals and health systems, hospices, trade associations, research institutions, health insurers, nonprofits developing affordable housing, and private foundations. As a firm, we are committed to both tax-exempt and for-profit clients and the collaboration and innovation that their businesses need to thrive in this complex environment. Assisting others in their efforts to realize their potential for success has been the hallmark of Reinhart's success. We will continue to offer opportunities like this program. For example, please consider marking your calendars for December 12th from 11 to 2 a.m. in Milwaukee, or December 13th from 11 to 2 p.m. in Chicago. On these dates, we will be offering roundtables with industry experts addressing the implementation of the Affordable Care Act. You may have received an e-bite. If not, you should receive one soon. Again, Tracy and I thank you, and we hope you enjoy the program. My partner, Heather Fields, will now introduce the speakers and the topic.
Good afternoon. Thanks for being with us here today. I'm really pleased that we could pull together such a great panel of speakers for you. And I want to walk through first a little bit of background on the case and then introduce the speakers, and we're going to get started right away. Obviously, today's seminar is going to focus on physician compensation and fair market value. I felt that it would be helpful to talk a little bit about one of the recent cases that's really causing a lot of us in the industry some heartburn in terms of nailing down what this fair market value concept really means for purposes of the Stark Law in particular, but also anti-kickback and from an IRS perspective, reasonable compensation. And today's presentation is going to focus on the various legal implications of what fair market value is and some thoughts on that. But one of the recent cases, Tuomey, that really raised this issue is a case that involved a small community-based hospital in South Carolina. It's, I shouldn't say that small, 301 beds, but this hospital was notified that by some of their physicians that the physicians were considering relocating their surgical procedures to an ambulatory surgery, and those are the facts reported in the case. And in response to this, the hospital needed to work with the physicians to see whether or not they could maintain their relationship with their specialists. And in particular, one of the specialists was an orthopedic surgeon who ended up unsuccessfully, they did not successfully enter into an arrangement with him, but he ended up being a False Claims Act relator, and that's what's caused the litigation in this case. But for a moment, let's go to the underlying facts. The underlying arrangement that was involved was a part-time employment agreement with a wholly owned Tuomey subsidiary entity. And this part-time employment agreement was offered to 19 different physicians, and they were all specialists who performed surgeries, gastroenterologists, orthopedic surgeons, and the agreement for employment would only be in place when these physicians were performing outpatient surgeries at the hospital. The physicians would be using the Tuomey facilities to perform outpatient procedures exclusively for a period of 10 years under these part-time employment agreements. There was a 2-year, 30-mile post-termination non-compete provision, and they had, in terms of their compensation, a tiered base salary that was tied to collections of personally performed services, but also a productivity bonus that could total up to 80% of net collections, and that's collections for all the procedures that were performed. And that's really an essential fact in this case because, frankly, the way the comp structure was set up, it was designed that the physicians would be able to capture some of the technical facility fees involved in the procedure, structured the productivity bonus. And they could also get an additional incentive of up to 7% of that productivity bonus for meeting certain quality measures, and they also received full-time benefits for a part-time employment arrangement. The history of this case is that one of the physicians, as I mentioned, orthopedic surgeon, who did not end up entering into an arrangement with Tuomey, brought a False Claims Act case that the government joined in on. And in March of 2010, there was a jury issued in the case that found that Tuomey had not violated the False Claims Act. One of the jury interrogatories on that case, however, related to whether or not Tuomey had violated the Stark Law, and the jury had found that Tuomey, in fact, had violated the Stark Law in that the compensation arrangements were not at fair market value and therefore didn't fall within the exception, one of the exceptions under the Stark Law. In July of 2010, when ruling on a number of post-trial motions, where a $45 million judgment was entered for the government, the judge had determined that he needed to set aside the jury verdict that Tuomey did not violate the False Claims Act and remand the case for a new trial. Tuomey appealed to the Fourth Circuit on that, and that appeal is the most current state of it. The case is now on remand, but that case is really the Fourth Circuit's opinion was particularly interesting because they found that in it they addressed two stark questions that were going to come up on remand. And one is that the technical component of the services that are billed to the Medicare program are in fact referrals from the physicians. They found that based on the statutory and regulatory language of Stark as well as commentary from the agency. And I want to clarify there. They read commentary from the agency. The statute and the regs does not specifically address whether or not the technical component is in fact a referral. So they actually went to commentary to make that determination. I want to make sure I'm clear about that. And then on the volume or value issue, what they looked at was the court said if a compensation arrangement takes into account anticipated referrals, that it does implicate the volume or value component of the Stark compensation analysis. And Nicole and Mary are going to go into more detail on that, but for those of you Stark fans, not fans really, people who follow Stark out there, that's going to be a really critical decision to see how the facts of this case are interpreted when looking at those two concepts. In the Fourth Circuit appeal where they did remand for a new trial, the government had argued very vigorously in this case that the Stark exception was not met because the compensation took into account anticipated referrals, and also, importantly, for Mary's presentation, that the compensation exceeded the 75th percentile. And I think a lot of people think that the Tuomey case stands for the proposition that the government feels that if you are above 75th percentile as based on national surveys and other nationally available surveys of salaries that you are not, you're going to be within a fair market value range. If you're exceeding the 75th percentile, then you are potentially getting into a gray area of whether you really have fair market value. So that's a little bit on the procedural history, a little bit on the facts. We are eagerly anticipating how that is going to turn out. And without further ado, I want to introduce our speakers. First, we have with us today Mary Hamans of Integrated Healthcare Strategies. She's with the Physician Services Practice, and she has been in this industry for over 20 years. We're very lucky to have her today. Steve Rice was unable to join us, and so we're very pleased that she was able to jump in. She is a senior vice president and has spent most of her time working on practice operational improvement projects and focuses now on physician compensation compliance audits, market research and surveys, the design and administration of new compensation systems, pay incentive systems, and performance management system redesign. She also specializes in physician organizational structure development and physician network development, and she has a national client base, which includes very large multi-specialty clinics. Prior to being with Integrated Healthcare Strategies, Ms. Hamans oversaw a 10-state operation for a national physician practice management company, and in that role, she was responsible for all the contract negotiations and overseeing over 400 physician arrangements and numerous support staff. In terms of her educational background, she has a degree in nursing from the University of Wisconsin and a master's in healthcare administration from the University of Minnesota. We're really thrilled that Mary could be here with us today, and I think you're going to learn a lot from her presentation. From Reinhart, we have with us Lucian Beaudry, who's an equity shareholder in our tax and business law practice group. He also works with the firm's executive compensation and tax-exempt organizations team. You heard that Larry mentioned we're really proud of our tax-exempt organizations team. It's for law firms, I should say. I work in the healthcare practice in our law firm. An interdisciplinary team is really unique, and Lucian's been a huge part of that. We work very closely with him in the healthcare department, and I think that interdisciplinary work has really allowed us to better advise our clients. Lucian is not only an attorney, but also has a CPA, and is an active member of the Wisconsin Institute of Certified Public Accountants, and he's currently the chair of WICPA's Federal Tax Committee. So we're very lucky to have Lucian today. And Nicole Rosen from our healthcare group is also going to talk a lot about the regulatory overlay of fair market value. She works in the health systems group in the healthcare department and counsels our clients on a wide variety of regulatory issues. But important for today, she is one of our Stark experts in our group and is going to be talking about fraud and abuse laws, the Stark law, the kickback law, and the False Claims Act. So we're really happy that everyone could be here today. Thank you for joining us. And without further ado, I am going to turn it over to Mary. Or maybe not. I think Nancy is going to.
Thanks, everyone.
So you use this clicker as a go forward? Okay, great.
Thank you. It's a pleasure to be with you today. A little bit about us. Integrated Healthcare is actually a bigger company than just physician services. But we're in the physician services group. We're in Minneapolis, and we've been around for 30 years. Oh, I do, so everyone can hear. Sorry about that. We've been around for 30 years, so it's hard to believe. And we work in anything in terms of physician services related to a payment between a physician and a healthcare organization. So whenever there's money exchanging hands, that's what we do. And so you can see that can be anything from comp model design, a lot of auditing that we do, looking at professional services agreements, management service agreements, employment compensation models, joint ventures, retention agreements, all of that. We are in all 50 states, so people ask, are you really in all 50 states? We are. We have clients in Alaska, and in Hawaii, so you can imagine which state people are fighting to work for. We're down in Mississippi, and we do a lot of work in the Midwest, but we are national in scope. We primarily are in Minneapolis, but we do have an office in Kansas City, Dallas, and we have one out in California as well. So fair market value, what is fair market value? Well, this is what fair market value is not. The first example is a physician who said, all I know is that I need to make more than my wife, who's also a physician, not taking into account that he's a primary care physician. These are actual true stories. And she is a GYN oncologist. So the organization had their hands full with that one. The second one is a potential client that wanted to have a 15-year, I'm sure you see those all the time now, 15-year terms on these agreements, no-cut contract, guaranteed, no performance requirements, and $1.2 million in guaranteed cash compensation. So obviously we had some trouble getting behind that one. I think you're noticing terms are getting shorter. The fair market value opinions are generally limited to 3 years nowadays. Third example, you can buy my practice. It's a common number you hear. Everybody's practice is worth what? $1 million. And back in the 90s, I've been doing this long enough, we used to see a lot of those, and nowadays those goodwill payments aren't what they used to be. So the value of the physician practices have really come down. And so now they're looking more and more at what can I do to increase my compensation. Cash compensation is becoming more important in these transactions because the value of their practices it's not what they thought they were going to be. Medical directorship, these are some things we never want to hear. I'm the biggest contributor to the hospital's bottom line. Just worth it based on my reputation. There are truly what we call luminaries in the industry. There are people that are famous, and they're really maybe just an N of one, but those are very few and far between. And in an organization, you may potentially have one of those individuals. You don't have all 40 of your employed physicians are not luminaries. 23 hours a day. I can't tell you, we do a lot of auditing, how many times I've seen on time reports where and you like this if you're an accountant, where it adds up to more than 24 hours in a day. That's usually a concern. And needed the money because he was going through a 5th divorce. And Steve's not here, but he one time had a meeting with the physicians where none of the physicians showed up, just their wives showed up for the meeting. So I think he's still trying to get through that one. But these are things you actually, a lot of times it's important when you're working on compensation relationships, a lot of things will come out that just aren't related or not important as part of what we're considering when we're looking at compensation. So we have to do a lot of redirecting and a lot of educating when we're working with both the physicians and our clients. What's appropriate to talk about, what's not appropriate. It's often good to have an attorney in the room for that very reason, to have everything attorney-client privilege. You spend a lot of time looking at the laws relative to this, and I won't get into this in detail as you're all probably more familiar with this than I am, but clearly when you look at the IRS regulations and Stark, under all these laws and regulations, fair market value is required. And that's always a tough thing because people say, well, what does that mean? What is fair market value? And it's a requirement, and there's our very short and abbreviated definition of fair market value. And I won't read this to you because then I run out of time. But I think the key here is it's defined as something that another willing party or another willing buyer would pay a comparable amount for the same services. So the key with that is you have to demonstrate that this is what the going rate would be in the market for similar services under similar facts and circumstances. So what are there's things that affect that. It's not always the same number. It's a range of values, and it can change based on a number of facts. So we do consider things like how productive are the physicians. We look at not just national data, but we also look at regional data. The government likes you to rely on published survey information. You can consider what's going on in a local market, but at the end of the day, you have to be able to tie that back to some benchmark information, especially in these local markets where they may be the only game in town. So they're essentially setting the market. Then it becomes even more important to be able to tie back to regional and national data. Overhead, is it a very lean practice? Are they running with just nurses instead of having a mid-level provider or APC for every physician? What's their payer mix and their reimbursement? We do see compensation vary quite a bit around the country depending on financials in the given market. So there's in the East Coast, you're going to see a lot lower paid physicians. In the southern part of the country, you find a lot of higher paid physicians. Texas still sees some revenue less expense models doing well, even in the Carolinas. Other parts of the country, New Jersey, very tough paramedics environment. Very difficult for physicians, often very much lower paid for the same work effort. So we do consider all those factors. But the bigger thing that I think our firm is looking at considerably, and other firms often don't look to, is commercial reasonableness. At the end of the day, what we're finding is not only do you have to be able to demonstrate that compensation is at fair market value, but is the transaction commercially reasonable? And we come up against these situations time and time again where, yes, the amount of the payment is within the fair market value range, but we can't demonstrate that it's a good business decision, that anyone else would do this business decision. And if you can't demonstrate that, the government's going to jump to, well, then you're paying for referrals, because why else would you be doing this? This doesn't make any sense. And I have one just current case where there's way more cardiologists than I would think they would need. And the physician's earning at about the 75th percentile, which you would expect is a safety zone, but they're producing around the 25th percentile. That starts to look like it's commercially unreasonable. Too big of a gap. Are they working enough hours? Could they do this different? Are they taking too much vacation? In this case, they all have 11 weeks vacation. So when you factor that in, then you would argue their pay in total, when you factor in the vacation, is really above the 75th percentile. So it's really more than just looking it up in a survey book in some of the cases. And then, of course, under IRS, it also requires you pay reasonable compensation to all employees, not just physicians and not just executives, but we tend to look at them most because they're the high-paid individuals. So it's a range. I think everyone wants, a lot of times when we get a call, they want us to come back with the number. And I certainly have an opinion on what I think the number is, but quite honestly, there's always this one standard deviation that any statistician can argue that you can work within, as long as you're within a range of what others would offer. And you really do have to have that facts and circumstances test. You have to be able to put out the good business case, show the business plan, show that the community needs this, and tie it all back to that. It's all very intertwined. It's just not you're paying below the 75th percentile, therefore it is okay. These are, I think we talked about Tuomey as one example, but these are other ones. And actually, if you put the whole list of settlements out there and the number of organizations under corporate integrity agreements today, this list will become very, very long. So there's often a number of settlements that come up quietly. We have had a number. You can go on the website and look at how many people are self-reporting, and there's a lot of people self-reporting all the time. And so that's always a challenge. When do you self-report, when you don't, when don't you? I had a client self-report, and the amount they paid in fines was actually less. It was a lot, but it was less than what they ended up recouping in overpayments. So they actually had. And oddly enough, they only lost one physician out of that whole situation. Only one person decided to leave. So it can be sometimes a good idea to self-report. What do you look to? These are some of the survey sources that we rely upon. We buy every survey you can find, and we recommend you don't necessarily do that because that gets to be extremely costly, but we're constantly looking to the market to see what are the most reputable, valid, reliable surveys available. And these are the only ones right now that also report productivity. So while it's good to look at some of the other ones in the industry, they don't have a production field reported. You can't necessarily figure out what you're looking at. We also have our own survey database, which is actually bigger than all of these three surveys. However, we haven't published it. We only allow our private proprietary database to be used by our clients. So it's just a decision our firm has made at this point. But anytime we do a project, we enter all our information into the data set. And so for some specialties, we have a much higher sample size than what you might be able to find in the published survey sources as well. One thing that's real important is not just what's being paid, but how it's being paid. So it's not uncommon to go in and see that the amount of compensation being paid is fine. You look, oh, they're getting paid the 60th percentile or the 55th percentile. But I was just out on the East Coast, and they had this problem. So their model was not compliant. And so there can be things in a model, like you mentioned, you cannot pay on ancillary technical revenue directly. We have some models where they're paying exorbitant amounts on mid-level or APC provider supervision. There are market benchmarks on how much you can compensate physicians these days for supervising an advanced practice nurse, which is just a nurse practitioner or PA. If you are earning as much as your own compensation as supervising one PA, that should be a flag. So that's important to look at. It first, is my model compliant? Is it producing compensation that's fair market value? And then secondarily, then testing out how much is it paying out. Payout rates, I think you mentioned in the Tuomey case, it came out that less than the 75th percentile of the market is a bright line their expert witness had put forward. That's a good place to look as kind of a place to say, does that make sense? Are we paying below that rate? Now, how do you know where you should pay? Because generally, if you read MGMA, you'd like to see those payout rates around the median, according to MGMA. So if you're going to go above a median payout rate, you have to start looking at why. Do we have really low overhead? Do we have an extremely favorable payer mix? Do we have a revenue less expense model where we have a group practice exception and we're pooling the ancillaries? Then you start having to go into, the bar goes up, and you have to start going into further analysis on those situations. Clearly, if you're below the 75th percentile, that is a safer place to be. But again, you have to be able to demonstrate that there's a community need for the position. You can't be just paying someone median compensation and they're not doing anything. And I have run into that a few times this year. When you really dig into a few of these positions, it's not clear that you're getting full-time services or what is the work effort that's being produced. So if you're not able to demonstrate that, of course, then it's going to look like a payment for referrals. So you have to ensure that the compensation being paid ties back to work effort, whether that's administrative work effort, clinical hours, call pay, those things need. This is an example. So here you have, and this is a lot of data, which I know everyone loves looking at scatter plots. But what this is showing is payout rates and compensation. So on the left, you're going to see P25 is the 25th percentile, all the way up to the 90th percentile. And so if you look at the corridor of kind of the higher risk zones we were mentioning, is looking at anyone paid above that red line. The red lines are the 75th percentile payout and the 75th percentile compensation. In this case, you don't have any individuals that are above that. So you'll notice the people that are above on the 75th percentile payout rate, those tend to be the new physicians, so they're lower paid. So it's not uncommon to see physicians that are right out of school building their practice. They're just not that productive yet because they're still building their patient base. They will often have these higher payout ratios that are going to be above the 75th percentile in some cases, but their compensation is generally around the median or below. And that's real reasonable and very common to see. You also notice there's some variability. So you're not going to see everyone necessarily line up on one of these lines because different people are performing at a different level on some part of their pay plan. If you're strictly on a comp per work review model, then you would see it line up right up along one of these lines. But if there's a quality incentive and someone earned it all and someone else didn't, you're going to see some variability in the information. Generally, most organizations will see these plot above and below the median line. And as long as they're staying within this framework, you're in a pretty safe zone when you're looking at compensation. But this is one of the testing criteria we look at as a firm. It's important to have a good process in place. This is the type of things we would recommend an organization go through. Build the business case, determine why it's strategically important to hire this, ensure you have all the survey information pulled together that you can pull together internally, making sure you can support your compensation models from an operational standpoint. Continue to look at it on an annual basis is really best practice. We've seen some models work really well, and then 20 years down the road they call us and they say this model's not working and you all put it in. And that's a real key. So things have changed. We don't see a lot of charge-based models anymore. Still see them in about 5% of the time though, believe it or not. But regulatory compliance, periodically doing an audit. Our firm will get called in on some of our clients just every third year to do an audit. It's good practice to do that periodically. Determining who does what is important, and these are examples of who might be accountable. This varies a lot by organization. You know, in some small organizations, you might have one person doing more than one of these functions. But it's clear to determine who's responsible because at the end of the day, if this ever comes back to audit, then everyone kind of claims no responsibility. So this helps to determine who is doing what do you need to have in the file. And these should be looked at every year too, because organizations are constantly growing in many cases, changing, and these change quite commonly. It's often a compensation committee nowadays. I was talking about this earlier today. It's often the same committee that looks at executive compensation, but it can also be the audit committee is a common place to see it, or the finance committee. And the things they do are certainly high level. You don't want them looking at every compensation arrangement, but they ensure that the plans are being appropriately administered, that things are compliant, and that there's a linkage between the vision and mission of the organization and the comp plan. And that's becoming more and more common. We have some clients where certain practices, based on how the comp model is designed, are not taking very many Medicaid or any Medicaid patients. Then that comes back, the board starts to talk about, is that a problem? Is that in conflict with the mission of our organization? Is our compensation program incenting behavior that we don't want to incent as a not-for-profit profession? And do we need to go back and look at it? Even if compensation is compliant, is it in conflict with what we want to do as a community organization? The key is that there's generally some philosophy and policy statements so that leadership and management can operate fairly safely within those zones. You don't want to have everything going to your board. And so as much as that can be put in place and revisited periodically with the compensation committee of the board. And then there are always going to be a few exceptions, and there should be a process in place to how to handle those exceptions. And documentation is key. So I've seen some organizations do a great job handling exceptions, and whoever's in charge leaves, and there's no paper trail, and it's all in just one person's memory. So that's always a risky place to be as an organization. I was outside of Kansas City the other day, and the CFO, she knows every contract, every reason for every single transaction, but if she were to ever leave, not much of a paper trail there. So they're starting to go through this process. They have a physician contracts administrator now in place who's starting to pull that together. The group generally does report to the board on at least an annual basis, sometimes twice a year. Similar to executive compensation, if there are any disqualified positions, you're going to see more and more of this because now more and more physicians are getting into executive roles, and some of those physicians are continuing to see patients. So our group, as a firm, we have an executive comp division, but if the physician is still practicing, then we price the position because then Stark is implicated if they're still seeing patients. And some of them might just be doing like 1 day per week in clinic, and then the rest of the time is in this administrative role. You're going to see more of these hybrid roles, and it's going to be challenging to know what do you pay some of these individuals? How much does it matter if they're an orthopedic surgeon, if they're the CMO too? Just a challenge in pricing some of these days. And then, as I mentioned, often important to look at regular audits. Even the best organizations who do everything, I hold them up in the greatest esteem for doing everything perfectly, even under a regular audit, generally find just a couple things here and there that they missed or administered incorrectly or could do better. Important that no one has a conflict of interest and people are excused if they're talking about a position in which they might have a conflict. They must rely upon comparable data, so they have to have market information, not just, well, this is what everybody's offering around town. They need to see actual published market information. There should be a rationale for their decisions. Those should be documented in the minutes. There should be some consideration of the long-term impact of the compensation plan, especially when an exception is made. And then also, somewhere there should be a determination. If you're getting beyond the policy, you should have an outside firm review and document why this is fair market value in this instance. Or if not, that's often when we'll get called in through attorneys, is when people are not certain. If you're not sure, you probably should work through your attorney. And that way it's all privileged. And sometimes you have to go back and make some changes. So that's not an uncommon situation. We work for a lot of attorneys, so it's not an uncommon situation to find yourself in as a client. Management can do a lot. I was speaking earlier, we don't want to become the physician comp department of the hospital. We do a lot of training of staff in HR to make them self-sufficient. We give them a lot of market information every year so they can do a lot of things on their own. They can obtain the published market information. They can run all the initial analysis internally. They can go ahead and check their compensation models to ensure they're staying competitive. They can administer their plan. And they determine when we need to be called in or be called in for an outside review if they're following their policies. So the best organizations have some really very qualified people doing all the day-to-day administration of the comp model. A lot of this can be done internally. In small places, sometimes it can't be, and then it's a good resource to use an outside firm. But in a larger organization, there should be an infrastructure in terms of this. And then every year, there should be an annual report back to the committee so that they can see in general, here's how our compensation for our physicians is compared to market, and anything on any outliers, and they can see why there is an outlier and that they've been reviewed, and just an update on the compensation programs and if there have been any changes since the prior year. And hopefully that's a quick meeting, and usually is, but occasionally some things will come up that require some conversation on the annual meetings. I won't read this flow chart to you, but this just gives you an idea of what we would recommend for a sample process to follow. But you can see that it's quite, there's a lot of arrows and they go back and forth with sometimes looping back in certain cases. But it's important you follow some type of process in the organization so that you can go back and show that one of the important things is that there is process being followed. It's not just one or two people making these determinations on their own. Things to avoid, these are case studies that we've seen that I think point out some really good concerns that are common. So stacking, you've probably heard of stacking as a common concern. When you have multiple negotiators, this is more likely to happen. So if you have someone negotiating call and another person negotiating medical directors, and if you're a larger health system, this is more likely to happen than if you have one person overall physician contracting. And so in this case, there was a family practitioner who had multiple arrangements, ER coverage, colonoscopy service, covering the hospitalist program, call, and multiple medical directorships. And all in all, it came up to $650,000. And when you really looked into these, especially you can see on some of the medical directorships and even on the hospitalist service, there was times when the individual was being paid to cover the hospitalist service, but also billing for the medical director services. And in some meetings, you'd have to argue, are you there as this medical director, or are you there as that medical director? So there's clearly overlap and double payment in this arrangement. East Coast Hospital, 95th percentile medical director rates were paid for neurosurgical services, and they were aged aggressively each year. This individual is producing over the 95th percentile clinically, filled over 1,000 hours of medical director time. And when we really looked into it, it was really operating almost as a chief medical officer type role, which in that case you probably would pay at a lower rate than a neurosurgical medical director rate. Some were neurosurgical duties, however. This is the case I mentioned about billing over 24 hours in a day. He billed to go to the Christmas party. And for a recognition dinner, we calculated about $15,000 he billed for preparation of the employee recognition dinner. And those are just a few examples. The audit was quite entertaining. There was a cap in this agreement that the CEO would take to the board and have it overridden, which was the board was relying on the CEO, and there is now a new CEO in place, let's put it that way, and this individual was let go. So you do see, when you start to see things that are high, that's not to say that they're not justified, but you do need to go through that extra step of having an auditor look to see, is this legitimate? And this was a real case where you could see a physician whistleblowing on this. His partners were extremely unhappy with him about this medical director payment that he was receiving. So his own partners were very unhappy. So that's where the risk goes up in terms of very possible case where they could be a relator. Another case, Southeastern Health System employed physicians under a work RVU model tiered productivity pay. No applications of the modifier. As mentioned, this is one of the most common situations I come across. You do have to apply the modifiers if you pay physicians under a work RVU model. The surveys require it if you're going to be using their benchmark data. Or you have to come up with a workaround, which is not ideal, which is artificially lower your rates, and then you have to demonstrate how you did that. And the problem with doing that approach is we find that physicians feel they're being underpaid. Everyone's getting $40 a worker review. Why am I getting 30? Well, we're not applying the modifiers for you. And they don't necessarily understand what that means. But what a modifier is, for any of you who haven't heard that term, is when you have a CPT code billed, if it's a multiple procedure, it gets discounted. So the payer will only pay half for the second procedure. And so you have to make that manual adjustment because the systems that you're reporting work reviews on will not make those. So you have to create some type of program to lower that work review amount by half. In an assist, it's generally 16%. And AMGA, MGMA, they put that at the front of their surveys, but I don't know if anyone really reads the whole. I do, of course. But other than your comp consultants, how many people will probably sit down and read the physician comp survey book from front to back? So in this case, there was a federal investigation in this case and a fine. This makes the case, I think what you often will hear physicians say, and I feel I have this conversation weekly with some physicians, is I produce at the 90th percentile, I should get paid the 90th percentile comp per work review rate. And the reality is those rates in the survey don't have anything to do with that. What they're essentially, that's usually often a new physician who's not that high paid and just doesn't have any production. So they spin off these high rates and MGMA publishes them. And so it's the most misused and misunderstood data table there is. MGA has put out multiple articles on this, cautionary articles, but of course not everyone has read them or seen them. But you'll notice that what you're going to generally see if you take a new physician, see how they have a high payout rate at the 90th percentile when you take their cash and you divide it by the productivity, it ends up being a high rate, a 90th percentile rate. As you move up and you see the very experienced physician, you can see in this example that we used, you take that individual's cash compensation, you divide by that individual's productivity, it ends up being the 52nd percentile for this particular specialty. So it's going to vary a little bit by specialty, but as you can see, the 90th percentile physician is not earning the 90th percentile rate. So a very common misperception in the industry. I often wish they wouldn't even publish that table because it's so commonly misused. Another case, too many negotiators. You have different people negotiating the deal and they're not all communicating with one another. And at some point, it becomes their pet deal. They fall in love with the deal. This has to go through. And it gets to the point where they've made verbal promises with potentially checking with others along the way, perhaps like they should have. And in some cases, because of the verbal agreement, administration feels it needs to go ahead with the deal just because it's made the representations. And as lawyers, I'm sure you've probably run into this. And then at some point, compliance gets involved and the lawyers get involved and try to pull the deal back. And so then there's a dissatisfied physician. And so if you go through the proper process on the front end before any promises are made, it can save a lot of headache and rework and bad feelings on the back end. And we get this frequently where even as a fair market value consultant, we sometimes get the fair market value request a week before they want to execute the transaction, which is clearly not enough time to do appropriate due diligence. And so bringing people in early is so important because if we find anything wrong with it, which sometimes we do, then now you're delaying the whole transaction or we're slowing it down and then people are frustrated. So I think that's too many negotiators not having the process and bringing in any outside attorneys and comp consultants late in the game can really end up in being a lot of bad feelings. Even in the end, if the deal ends up going through in a compliant way, it still doesn't end up feeling positive to all the parties involved. A Southeastern Trauma Center, highly competitive market, hundreds of compensation arrangements. Some of our clients have hundreds upon hundreds of contracts with people. It's just, their contracts administrators are very busy. That's all they do is try to keep track of when these are due. It's often a problem is they'll have reset provisions in contracts and they come and go and no one caught them and then they'll call and say, oops, we forgot to reset the comp. Now we're 8 months past and what do we do? So this is a case where they had a lot going on, trying to keep track of it all was a problem. But there's always the hearsay. I know a guy, or I was at a conference, and I had the most recent, all my friends make more than I do. I'm the only neurosurgeon making $2 million. All my friends make $6 million. And I know that. So then you start digging into it, and what you find is they're not exactly matches. So, okay, what do your friends do? Well, they own all these ambulatory surgery centers. Okay, so they're not employed by a not-for-profit organization, and they have other business interests that's not their professional income. They're making money off these other ventures that they're in. So often it's not an apples-to-apples match, but yet they don't know all the details. And so in this case, this did result in a number of bad deals where they were thinking they were matching the competitor across town, and the reality is they were actually exceeding what the competitor was doing across town. I think that was my last slide. So with that, I have a couple questions, and I should have put my glasses on. The first one says, a lot of what I'm hearing so far relates to Stark's Law. What are the implications for hospice physicians? So that's a good question, because hospice physicians, you can argue those aren't their own patients. So same thing with emergency medicine or anesthesiologists as well. You can always say, you kind of look back and say, well, they're not directly referring the patient to the hospital, therefore Stark is not implicated. And you as lawyers can argue that, whether you think it is or isn't implicated under that. However, under IRS, you're still required to pay fair market value to all your employees. And so it's important to consider that. And when you look at physicians, they obviously all know each other and can influence each other in terms of if you're referring patients to me and I have a relationship with you, a lot of them are friends and such. With all their indirect relationships, I think it's important that you treat them all the same and have common policies and processes, regardless of if they're a hospital-based physician or not a hospital-based physician. I have a situation right now, awkwardly, where they're paying a private group more. It's compliant, what they're paying the private group, but they're paying them more than their employed hospitalist group. And so you get in an awkward situation there where you're saying, why? Is it because that group refers patients? Because they're in a multi-specialty group and your employed doctors do not? So that's one we're having them redo right now. Hospice physicians, I think when you look at those individuals, they're trying to reduce care. Some people would argue. They would argue they're not. They're just trying to provide appropriate care to those patients. Palliative care is getting to be a bigger and bigger specialty. What you're finding with those individuals, they're not that's not a high-paid specialty. You do occasionally see an oncologist move into hospice, but it's not an area where it's not your top-paid specialty per se. And their incentives tend to be focused. Still, they're highly salaried at this moment. You don't see a lot of incentive plans for those individuals yet. I think when we start getting into more incentive plans for that, you're gonna have a lot of interesting conversations around what is quality, and you can't obviously pay for less care, so it's an area you have to be careful. Another question regarding a comp committee for physician comp, disqualified individuals, physicians. Disqualified physicians are often going to be the same physician, like your executive folks, so the definitions that you're using for your executive physicians are going to be the same. So they tend to be the physicians in the leadership roles that I mentioned. And so I think you're going to see more of those physicians showing up on the list of disqualified individuals. Healthcare clients define that list some more narrowly than others. So some of that is a determination that's made by the organization. But we're starting to see more physician executives showing up on that list. Any other questions from people in the, I don't know if they typed them in or? Okay. Okay, great. Thank you.
Mary, thank you so much. That was very insightful and really practical advice, and we really appreciate it. We're going to hear now from Lucian, and then from Nicole, and then Lucian. And we ask that you hold your questions to the end. We will get to as many of them as possible. We wanted you to have as much time as possible with Mary, so we will condense our remarks to about 10 minutes and then turn it over for questions.
Okay, so now that you've heard about fair market value from Mary, I'm going to talk a little bit more about the fraud and abuse healthcare laws that are implicated by fair market value. And there's two main laws that are implicated, and the first is the anti-kickback statute. And again, I know a lot of you probably already know some of this intro material, but I'm going to go through it quickly just to give the background to those who don't. The anti-kickback statute prohibits knowingly and willfully offering, paying, soliciting, or receiving anything of value to induce or reward referrals or generate federal health care program business. Anti-kickback statute is a criminal statute. The other fraud and abuse law is the Stark law, and that is a strict liability civil statute, and it prohibits a physician from referring Medicare or Medicaid patients for certain designated health services to an entity with which that physician or his or her family member has a financial relationship, unless an exception applies. In turn, that entity that receives the referral is prohibited from billing Medicare and Medicaid pursuant to those referrals. Quick side-by-side comparison, the big difference is that the anti-kickback statute prohibits referrals from anyone, where Stark only prohibits referrals from physicians. Anti-kickback statute prohibits referrals of any item or service, and Stark, as I said before, is just designated health services, which are defined by statute and regulation. Anti-kickback statute applies to all federal health care programs, where the Stark law only applies to Medicare and Medicaid. And because the anti-kickback statute is a criminal statute, intent must be proven, whereas the Stark law is strict liability. No intent is required whatsoever. There's also, each law has a series of exceptions or safe harbors, and for the anti-kickback statute, those are voluntary safe harbors. If you can meet that safe harbor, you're going to protect yourself from liability under the anti-kickback statute, but not meeting a certain element of a safe harbor does not mean that you are per se in violation of the anti-kickback statute. On the other hand, the Stark law is strict liability. You must meet every single element of a Stark law exception. And then in terms of sanctions, anti-kickback statute is going to have civil and criminal sanctions, and Stark law is going to have just civil sanctions. I said that both the Stark law and anti-kickback statute have exceptions or safe harbors. There's about 4 that deal with physician compensation, and those are going to be the employment exception, the professional services exception, physician recruitment exception, and fair market value compensation. The names vary a little based on the law, but generally they require much of the same thing. With the exception of employment arrangements, most arrangements have to be set forth in a signed written agreement. Typically have to be a term of 1 year or more, and then they all require that compensation is fair market value, set in advance, doesn't take into consideration the volume or value of referrals, and the entire arrangement is commercially reasonable. As I said before, the civil sanctions, or the sanctions for anti-kickback statute and Stark law are going to vary slightly, but the civil sanctions are very similar. The big difference is in terms of the anti-kickback statute is you have a civil assessment of up to 3 times the amount of the kickback, whereas for Stark, you might have non-payment or recoupment of all payments made based on tainted referrals, and then civil assessments up to 3 times the amount of the claims submitted. And then anti-kickback, there's also criminal sanctions, to include fines and prison time. There's a few mechanisms that the government uses to enforce these laws, and the first is the False Claims Act, which imposes liability on an entity for knowingly submitting a false or fraudulent claim for reimbursement. And both the Patient Protection and Affordable Care Act, as well as the earlier FARA, which stands for the Fraud Enforcement and Recovery Act of 2009, have given the government additional teeth in using the False Claims Act to enforce Stark and anti-kickback. First of all, FARA broadened the definition of knowingly in terms of the anti-kickback statute, so an individual no longer has to have knowledge of the anti-kickback statute or intent to violate the statute as long as they're knowingly offering remuneration for or to induce federal health care program referrals. Also, FARA imposed False Claims Act liability penalties on individuals who knowingly conceal or avoid an obligation to pay the government. And subsequently, FPACA made a 60-day report and return requirement on all overpayments. So those together result in new False Claims Act liability for an organization's failure to report and return overpayments within the 60-day time period. Sorry. There's also the civil monetary penalties law, which the OIG can seek and assess CMPs for various types of conduct. And with the PACA now, they can seek CMPs also for failure to report and return overpayments. And overpayments are going to be any payment received in violation of STARK or anti-kickback statute. And then PACA also has several other provisions which help the government enforce STARK and anti-kickback. For example, there's increased funding, about $350 million additional funding to fight fraud and abuse in the Medicare and federal health care programs. There's also a new requirement that most providers will have to have compliance programs in place to address issues like these. And then there's also the Self-Referral Disclosure Protocol came about, SDRP, which was a mechanism to allow providers that do discover STARK violations to disclose that to the government. The OIG had a similar protocol, or has one, for anti-kickback violations, and used to also accept STARK violations, and have kind of pushed away from that. So now there's a place where providers are able to bring their STARK claims to. And this is just a brief listing of recent enforcement actions, and I'm going to go through some of the lessons learned from these. So the first, activity-based compensation, and making sure that your compensation makes sense in light of the productivity. This Tuomey was a great example of that. The government, Heather mentioned earlier also, the government proposition throughout that was, as long as you are under that 75th percentile of compensation per work RVU, pretty much put a bright line rule that you should be within fair market value, but anything above that needs to be justified. Also stacking, which is another concept that Mary had talked about, but stacking pretty much means being paid for two or more services at the same time. And there is a case, SCCI Hospital in Houston, where the government had challenged the reasonableness of 3 medical director arrangements, where the hospital had hired their top referring physicians also as medical directors, and were pretty much the same medical directors for the same departments. They didn't need all the medical directors, so there was a big question on whether it was commercially reasonable. And I think they felt like you can just stack on another thing and pay for more. You need to make sure that as you're stacking that each component is identifiable, measurable, and recorded, that you're documenting different aspects of the arrangement. And then also whistleblowers. Almost the majority of cases, with the exception of 2 that have come about recently, are based on whistleblower actions. Tuomey, for example, as Heather mentioned, was brought by a physician who Tuomey was unsuccessful negotiating an employment agreement with them. There's also a case, Covenant, where a False Claims Act suit was initiated by an independent practice who complained that Covenant was providing excess compensation to their physicians. Before filing that claim, the independent group had unsuccessfully brought an antitrust suit, alleging that the high salaries paid by Covenant made it impossible for their group to compete for physician talent in the area. Another big issue is going to be reading the fair market value opinions. In the case Bradford Regional Medical Center in 2010, the hospital had paid non-variable compensation to several physicians in a cardiology group through an equipment sublease agreement. So it did not appear that it was varying with the volume or value of referrals because they were paying the same compensation. However, they had hired a local CPA to value the arrangement, and when that CPA testified, he testified that his valuation assumed that the group of physicians was going to refer patients to the hospital. So the court ruled that the compensation did take into account anticipated referrals, and the hospital was found to have violated Stark and anti-kickback despite having this independent fair market value opinion. So the big takeaway there is that you need to read through, you need to read the fine print, you need to make sure that the valuation methods are in line with the laws that you're complying with and also with what is actually happening there. Before I get to practical strategies, a few other lessons learned from Tuomey is the fact that the physician is being paid for personally performed services. As Heather mentioned again earlier, that technical component is now viewed as a referral. So that opens up a lot of these arrangements where otherwise there weren't many concerns in terms of at least the Stark law. There should be concerns now about that. Also, it showed that employment contracts aren't as perfect and safe as they were once thought to be. So to make sure that those employment contracts, even though you don't have the same strict requirements where you need a written agreement or a one-year term, you still need to meet fair market value and commercial reasonableness. And the last one is a lot of these cases focused not only on fair market value, but also commercial reasonableness, and making sure that it is essential to the functioning of the hospital to have these agreements in place and that there's mechanisms to check and make sure that those agreements continue to be necessary for the hospital. In terms of practical strategies, really the big one is carefully structuring your arrangements on the outset instead of trying to work backwards when you realize there's a problem. If you adopt physician compensation policies or plans that have safeguards and mechanisms built in, you shouldn't have to be working backwards in the future. As part of those physician compensation plans, you want to consider the role of legal counsel, the role of fair market value independent consultants, at what point you may feel like it is necessary to have an independent consultant, as well as also how you're going to document your arrangements. So if you want to make sure you have fair market value and commercial reasonableness documented, if you don't have an independent consultant, you want to make sure you're laying forward exactly what surveys you're using and consistently using similar surveys or similar mechanism internally to develop compensation. Hospitals should also consider periodic audits of their arrangement to make sure they comply with Stark and anti-kickback, so that same terms are being followed and that fair market value hasn't changed or the law hasn't changed. There was a recent case where one provider just never changed their agreements after the physician recruitment exception had completely changed. So they had not considered changing current agreements at that time. The big thing is just don't wait to address Stark and anti-kickback problems until you're about to close on a merger or acquisition and you realize it at that point, because the government takes advantage of your need to get through due diligence at that point. So if you audit and you are proactive on how you handle either the arrangements to make sure they are compliant or handle non-compliant arrangements if you find them, it's going to put you in a lot safer position. And finally, being proactive with respect to whistleblowers. Clearly, whistleblowers are bringing forth the majority of actions dealing with Stark law and anti-kickback statute. So adopting strategies and policies as part of your compliance programs, offering various well-publicized channels for employees or physicians who do not like the way something's going to report it and feel like their report's going to make a difference is going to prevent a lot of that whistleblower action from happening.
Okay, I'm just going to mention a few things because I thought the previous speakers did a pretty good job. At least, you know, Mary, when she mentioned some tax exemption issues. And again, I'm just going to talk about a few tax exemption issues with physician compensation. Before I mention that, I just want to note I'm not going to really be talking about all tax issues. And you know, when an IRS does an audit, they're looking to raise revenue. They're looking for low-hanging fruit. And one thing you might see them looking at quite frequently is not necessarily the amount of the compensation, but certain other aspects of their employee benefits, like are they submitting expense reimbursements under an accountable plan. You know, if there's things like that where they can actually get revenue from it, you might see them focusing more on that rather than the amount of the compensation in certain circumstances. So what are the key issues? Well, one of the fundamentals of being tax exempt is you have to be organized for public rather than private purposes, and you can't have any of your profits inure to the benefit of any private person or shareholder. And out of sort of those two general statements come these two concepts of private benefit and private inurement. They're oftentimes confused, but they're not necessarily the same. The private benefit concept, it deals more on a global basis, and you can't have more than an incidental amount of private individuals benefit. I mean, just about everyone benefits, or you know, just about every exempt organization has a private person who benefits. If you're working for them, you get a compensation. But that's incidental to them serving their overall public purpose. Private inurement, on the other hand, deals with when you have an insider. And that's typically someone who's in control, someone who has a substantial influence over the organization, and that person is somehow getting the profits of that organization. That deals with private inurement. You can't have any private inurement at all. They have to revoke your exemption, or your exemption's lost if you have private inurement. Now, up until 1996, that was the only tool at which the IRS had if they, quote, found private inurement. In 96, they came out with intermediate sanctions, and essentially that's a system that allows the IRS to impose penalty taxes and cause people who get private inurement to force them to pay the private inurement back, so to speak, their excess benefits back, and pay a tax. Now, on the compensation side, as was mentioned before, Code Section 162 governs whether compensation is reasonable. And you know, the general standard is it's an amount paid for like services by like enterprises under like circumstances. That's what the reg says. From that general language, we've essentially have three standards in the federal courts. One is a multi-factor test. The second test, which is in the Seventh Circuit, is called the independent investor test. And the two seminal cases in that area are Exacto Spring and Menards. And this law firm was involved in litigating both of those cases. And the Seventh Circuit, frankly, has probably the most favorable standard in the whole country as far as what is reasonable compensation. Now, the independent investor test doesn't necessarily translate very well to physician compensation. It's a test that basically determines whether the CEO is producing enough of a return to its investors to justify that CEO's compensation. And you know, these are in the context of C corporation cases where essentially you have private owners who are trying to zero out compensation or pay as little corporate level tax as they can. It's sort of a different test. You know, if you want an interesting opinion though, read the Menards case. It's probably the only opinion I've ever seen that has exclamation points in it. I mean, they lambasted the IRS, and even though the dollar amounts were very large for the CEO, who was the sole owner in comparison to the other owners, that it was a complete taxpayer victory, even for large amounts. Now, in these cases, and I've been involved in litigating them on a number of cases, you still have the battle of the experts, so to speak. Each side, the IRS will get an expert, we'll get an expert, and you have two experts who will be like this on the same issue, and then the court tends to decide it. And I think if you have that contemporaneous documentation, as Mary was talking about before, and you go through the intermediate sanction safe harbor, I think it gets you a long way towards winning those cases. Some other issues that have come up, at least in the context and some things I've worked on, and that is Form 990 has changed in recent years. Now you have to actually disclose on the return if you are complying with the rebuttable presumption. You have to tell them, and everyone can go out there and look at it. And if you say, no, we're not complying with that rebuttable presumption, then, is that a red flag for an audit? Is that a red flag for donors? Is that a red flag for the media? I mean, you see more and more compensation issues hitting the media, or people will use compensation issues to sort of badmouth competitors. You're seeing that from time to time. And then bond opinions. If you're issuing tax-exempt bonds, a lawyer out there has got to actually look at the organization and say, yes, it is our opinion this organization qualifies as a 501c3 organization. Now, if you're not sort of going through the rebuttable presumption of reasonableness and you don't have data backing it up, or perhaps you see some articles out there, talking about some news articles about compensation for this organization, you as the lawyer might get a little bit nervous. Okay, I want to leave a few minutes for questions. I thought we went through the intermediate sanctions pretty well. I just want to mention a few things on this. The IRS at one point took the position that all physicians are insiders. And since they took that position in the 80s, I use the word disqualified person, and really the standard was insiders when they came out with that. They've kind of backed off that. And now I think it's fair to say that your physicians who are on your board of directors, your physicians who are in executive officer positions, and possibly even some of your department heads and things like that will probably be considered a disqualified person. But if you have a brand new physician in a 200 employed physician organization, that person probably is not going to be a disqualified person. I mean, you have to be in a position to exercise substantial influence over the organization. We talked about how you get the rebuttable presumption. I just want to mention a few other things that weren't mentioned. When you look at the first conflict of interest issue, one key thing to remember on that, it's not necessarily a conflict of interest between the person who's approving it and the organization. It really relates to the relationship between the person on the board who's approving it and the individual getting the compensation. Okay, so you have to look, are there transactions between this person and the individual who's getting compensated? An example might be if you're a lawyer but you don't represent the organization, but you represent a physician on all of his real estate dealings on the side or something like that. That might be a conflict of interest where that person would have to recuse themselves. I think we talked pretty well about what constitutes appropriate data and what you want to have on there. And we talked pretty well about the adequate documentation and how to approve that. Note that there are time periods in which you have to have this stuff documented. It's generally 60 days after the meeting or before the next meeting. So keep that in mind so you can get that rebuttable presumption. All right, how are we on questions? Are there any? Does anyone have any questions from the room for any of the speakers? All right, that's all I have. Thank you.
No questions. Well, it certainly gave us a lot to think about, and I first want to thank Mary for coming today. I thought that your slides were incredibly insightful and really practical, and that advice is just really, really helpful as we all think about the day-to-day operations of our clients and the people we're working with and how we're going to translate this down. Nicole and Lucian, thank you as well. Thank you to everyone for attending today, and we hope you'll be able to join us for our Affordable Care Act presentations. No more questions, Nancy? With that, I think we will end today's presentation. Thanks again for coming.